Merci beaucoup. Premièrement, il faut que je m'excuse. J'aime bien la langue française, mais malheureusement, je ne la parle assez bien pour donner une présentation en français. And that is why I'm going to change to English and why I'm going to give my presentation in English with your kind permission. Now, in the Odyssey, one of the adventures that Ulysses had to brave was to navigate the strait between Scylla and Charybdis, two monsters. Scylla would eat up the sailors, whereas Charybdis was a torrent which would pull ships to the ground. Ulysses had to steer the middle course. He did not an excellent job because on his way back some of his companions were actually eaten. Now, this picture of Scylla and Charybdis is actually quite a happy image when we're talking about intellectual property and trade secret policy. In intellectual property law, the one rock is called overprotection, which may stifle competition and which may stifle the freedom of expression. And the other rock is called ineffective protection. We have intellectual property rights for a reason. And if this reason makes sense, we want intellectual property rights to be effective. And the same applies to trade secret law. On the one hand, we should try to avoid an absolute intellectual property type protection, because that might conflict with, for instance, patent law policy. On the other hand, we want protection to be efficient and we want it to be transparent because otherwise it's of no use to businesses. This middle course is exactly what the Commission is trying to steer with the proposed directive. And the question for us when discussing this directive is whether the Commission has achieved this task or whether the Commission is in danger of steering the European boat onto one of those rocks. This is what I would like to discuss in the 15 minutes that I have, and I would like to start with some general observations on the proposed directive. Now, first of all, I absolutely agree with Mr. Bergevin that there is a great practical, great economic importance of trade secret protection, and that so far trade secret protection in Europe is deficient. We might even go so far as to call trade secret law the Cinderella of intellectual and unfair competition law. Why? Because, first of all, protection is inefficient. Secondly, there is relatively little case law compared to the other areas of intellectual property. And thirdly, we in the academia also sometimes tend to neglect trade secrets. We know a lot more about copyrights and patents, for instance, and about unfair competition law than about trade secrets. There are enormous differences between the laws of the member states, and that is not good in Europe, because as Mr. Bergevin has rightly stressed, trade secrets are very important for interstate commerce, for collaboration between enterprises in various European countries, and for cross-border dealings. Trade secret protection also has an impact on fundamental freedoms, on the free movement of workers, on the free movement of services, and even on the free movement of goods. So there is a good case for attempting harmonization in this field. When we look at the directive, we find that there is a sort of divergence between the title of the directive and the operative part of the directive. The directive only talks about trade secrets. It doesn't distinguish between technical secrets on the one hand and business secrets on the other. But when we look at the title of the directive, it talks about know-how and business information. So here we do have this dichotomy. I find that slightly puzzling, in particular because the term know-how is defined in community law. It is defined in antitrust law, in the technology transfer block exemption, and it's a bit puzzling that this same term is used in the title here. Another question that is bagged by the proposed directive is a question which we often ask when we talk about directives in this field. Is this a minimum harmonization, as we find it in the TRIPS agreement, or is it a total harmonization, meaning that the member states are not allowed to provide for stricter standards? Very difficult to say. There are some provisions in the directive which obviously aim at a total harmonization. For instance, the limits of trade secret protection, they wouldn't make sense if the member states could be stricter than that. But when it comes to the remedies, we don't really know. I think it would make sense and it would enhance the harmonizing effect if the directive was actually, or achieved actually, an overall harmonization rather than just a minimum harmonization. Next fundamental question. Now, I'm supposed to comment on the directive from a competition law angle rather than from an IP angle, but let me nevertheless say this. One interesting question is, does the directive create a new intellectual property right? No, says Recital 10 to the directive. No, says Mr. Bergevin. But there are some elements of this directive which I would call, well, an Englishman might use this terminology, they sound IP-ish, which means they feel a little bit like intellectual property law. For instance, the directive talks about infringers, it talks about infringing goods. That is intellectual property language. And even more seriously than that, the directive seems to assume that perhaps the Intellectual Property Enforcement Directive of 2004 might apply as a subsidiary source when it comes to securing evidence. That, however, would presuppose that we are actually talking about intellectual property here. So this is still a very open question. Let me very briefly look at the provisions of the directive. We have already talked about the definition of what a trade secret is in our discussion after the first presentation. The Commission is following Article 39 of the TRIPS agreement here. The definition in Article 2 is more or less a copy of the TRIPS agreement. This basically makes sense because this is an international obligation and it's good to take the text which we already have and which we've already agreed upon. But I'm also a little bit hesitant about this requirement that we already discussed, reasonable steps to keep secret. A trade secret will only be protected if there have been reasonable steps to keep this secret. Now, this may at least lead some courts and some member states to require excessive steps to keep things secret. We need protection of secrecy even for documents, for instance, which are not explicitly classified as being secret. What are reasonable steps? This is an open question, and this is a question where some courts in some member states might tend to impose excessive hurdles. Then, in Article 2, we find this definition of infringing goods. This sounds very much like intellectual property, more than like unfair competition law. There are no infringing goods in unfair competition law because unfair competition law is not about property rights, it's about actions in the market. But Article 2 talks about infringing goods, namely goods whose design, quality, manufacturing or marketing significantly benefits from trade secrets unlawfully acquired, used or disclosed. These goods can be seized, they may be destroyed in some certain circumstances, very much like we know it from patent law or from copyright law. However, this might go too far. I agree with this when a design, for instance, rests on a trade secret. That is, when a thief steals documents and then constructs goods according to those documents. But take the word marketing. When does the marketing of goods significantly benefit from trade secret protection? Perhaps someone's stolen a business plan or consumer lists. That would be a theft of trade secrets. But is this a reason to actually stop the goods? I think here the IP type protection is going much too far, and at least the word marketing would have to be omitted. Then Article 3 is of central importance because Article 3 defines what an unlawful acquisition, disclosure, and use of a trade secret is. First of all, I like it that the directive tries to give more details to which behavior is unfair. Those of you who have read Article 39 of the TRIPS agreement will know that such a definition is missing in the TRIPS agreement. The TRIPS agreement only talks about unfair practices, and then it defines some of those unfair practices in a footnote. Well, this is more elaborate, and I think it's very important for harmonization that it should be. However, there are some elements in this definition which are difficult. First of all, subjective elements. In Article 3, it is said that there will only be an unlawful acquisition or disclosure if there is intention or gross negligence. This doesn't always make sense. Sometimes it's superfluous. Article 3 talks about theft and bribery. Well, you can't have theft without intention. I don't know whether you've ever stolen something unintentionally. I haven't. Here we don't really need the subjective element. But sometimes it's too restrictive. If there is a breach of a contractual duty, if you are under a contractual duty of confidence, intention doesn't matter. You have to keep that duty, regardless of whether you're intentional or negligent. One major problem has not been addressed in Article 3, and we might talk about that a little bit more when we come to the comments from the perspective of labor law. That is the position of employees, especially the position of employees after the termination of their employment. That leads to a lot of litigation in the courts. That leads to cross-country problems when one employee goes from Belgium to Germany, for instance, to carry on working there. There would be a need to find rules in this area, and the directive is completely silent on that. I understand why the directive is silent, because that's a very tricky issue, which has impact on contract law and labor law. But nevertheless, it's a bit of a pity, because the directive is not complete in that area. How about the limitations of protection? Lawful acquisition and disclosure, Article 4. This is a very important aspect. I think it's very good that the directive should mention that, because some of these borders are not very clear in some jurisdictions. Take my own country, take German law. The prevailing view in Germany is that reverse engineering actually amounts to a breach of trade secrets. Reverse engineering is illegal in Germany. Whenever I talk to American colleagues, they can't believe me. And they tell me, look, this is probably not true. You have misunderstood German law. And then I tell them, look, I'm a professor of intellectual property law at the University of Munich. I know. So we do have a problem in German law there, and we do have similar problems in other European jurisdictions. So it's very good that these borderlines should be defined. However, one should point out that reverse engineering is not legal per se. It can infringe copyright law, for instance. So the directive should make it clear that it has no impact on other intellectual property rights, such as copyright law, which might restrict the freedom of reverse engineering. Some of these limitations here are pretty vague. Article 4 talks about legitimate interests, freedom of expression, and so on and so forth. I think Mr. Bergevin in his presentation used the word safe harbor. Well, if you imagine a harbor has walls, and these walls are normally very fixed walls. Well, this safe harbor provision has fairly uncertain walls. We don't really know where the limits are. So in that respect, I understand why there are general clauses. In trade secret law, it is impossible to define all the cases where the use is legitimate. We need general clauses, but perhaps there are just a bit too many of them in Article 4. Sometimes I would have preferred in Article 4 to find a reference to the necessary balance of interests. So it's, for instance, legitimate if there is a legitimate use of freedom of expression, or if a legitimate interest is protected. Well, freedom of expression always needs to be balanced against trade secret protection. Perhaps that's why there is the word legitimate. So perhaps legitimate means that there needs to be a balancing of interests, but I think it should be made a little bit clearer that all these interests in Article 4 may be perfectly legitimate, but they may need to be balanced against other interests. How about the consequences, the sanctions in case of a breach of trade secrets? Well, first of all, in the Intellectual Property Enforcement Directive, there is a great provision. That's Article 3, Paragraph 2, which refers to what I would like to call the three sisters of enforcement law, namely effectiveness, dissuasiveness, and proportionality. Now, these three sisters have been separated in the directive. We find effectiveness and dissuasiveness in Article 5. We find proportionality in Article 6. I would have preferred to find the same principle that we find in the Enforcement Directive, because these are the three things that we always need to keep in mind when enforcing rights. Article 6, paragraph 2 says that courts may award sanctions in the case of a manifestly unfounded and bad faith application without prejudice to damages. I haven't quite understood what exactly that means. I think there should be a provision which allows for damages. That is, if someone gets sued for the violation of trade secrets and that person has legal costs and the action was unfounded, there should be a possibility to claim damages. And it's good that the directive should say that, but Article 6, paragraph 2 at the moment doesn't say so terribly clearly, and I think here there is need for clarification. Limitation periods, we've briefly talked about them. I doubt a little bit whether we should start introducing limitation periods into European law just here. There are no fixed limitation periods in European copyright law, no fixed limitation periods in European trademark law. I don't know whether we need them at this place. Certainly 2 years after the moment when a company had reason to become aware of the problem is much too short. Because a reason to become aware, that may be very early. And from the moment that you have reason to become aware until the moment that you prepare your case and that you actually send out cease and desist letters or that you apply to a court, just 2 years, that's far too short in my view. Procedure and remedies, I don't have much time to speak about that, just some very, very short remarks. First of all, the relation to the enforcement directive. Recital 28 says that this directive is to be a lex specialis. It's not quite clear what lex specialis means. Does it mean that the enforcement directive is not applicable at all? Or does it mean that the enforcement directive is applicable when this directive is silent? For instance, when it comes to securing evidence in Articles 6 and 7, where this directive is silent. Well, if in this case the enforcement directive applies, that would presuppose that trade secret protection is intellectual property law. If trade secret protection is not intellectual property law, we are left with our national statutes in this area, which are terribly, terribly unclear. So I would have preferred a full lex specialis approach, deal with everything in this directive, because only that does away with the unclarity that we have at the moment. In-camera proceedings, can you actually exclude the other party from a court hearing? Well, the directive says this can be done, and I see why this would make sense, why this would make enforcement of trade secrets much more practical, but there are constitutional problems here. I talked about this directive in a talk at Munich, and one of the judges of the Munich District Court was present, and he immediately got up in the discussion and said, I think that this Article 8, if it was to be implemented into German law, would be unconstitutional. I would immediately forward it to the German Constitutional Court, asking whether it is compatible with fundamental laws, that is, with the right to a fair trial, which sparked a discussion of whether the German Constitutional Court is in charge or whether the Court of Justice in Luxembourg would be in charge, but nevertheless, there are a couple of problems out here. I guess I should leave it there and should make one final remark. Has the Commission achieved its goal of steering a middle course? I think by and large, yes. I think by and large, this is a very good instrument which balances these two interests, and certainly with respect to my own jurisdiction, to German law, the implementation of this directive would be much better than what we are having at the moment. So I think the Commission should go ahead. I hope that this directive will enter into force despite some minor questions which I have addressed and about which we might still need to discuss. Thank you very much for your attention.
Thank you very much, Ansgar, for this very clear presentation.